the Department of Homeland Security versus the Regents of University of California. So the Deferred Action for Childhood Arrivals, or DACA program, was created by the Obama administration in 2012. This program was created to provide protections for youth that were brought to the United States illegally by their parents. The program allows the youth to work, get an education, get a driver's license, and temporarily protect them from deportation. In 2017, with the switch from the Obama administration to the Trump administration, the Department of Homeland Security began to phase out the DACA program. They claimed that the creation of DACA by the Obama administration was an unconstitutional exercise of authority by the executive branch because the administration had created it without proper statutory authority and with no established end date. The plaintiffs argued that the decision to end DACA violated the Administrative Procedure Act, or APA, because it was arbitrary and capricious, and it violated the APA's notice and comment requirements. As well as that, they argued that it violated the equal protection and due process clauses of the 14th Amendment. The United States Court of Appeals for the Ninth Circuit refused the Department of Homeland Security and government's motion to dismiss the case on the grounds of lack of jurisdiction, as well as that the United States Court of Appeals permitted a preliminary injunction in favor of the plaintiffs, which allowed DACA to remain while the case was awaiting ruling. For the Supreme Court of the United States, the petitioner for this case is the Department of Homeland Security, and the respondent is the Regents of the University of California.
There are two main issues prevalent in this case, which are whether the Department of Homeland Security's decision to wind down the DACA policy is judicially reviewable, and the second one is whether the Department of Homeland Security's decision to wind down the DACA policy is lawful.
Our decision was affirmed by an equally divided court. This meaning we were a deadlocked 4-4 decision since Kavanaugh recused himself. Thus, no decision was made, and the decision of the lower court stands, so no precedent is set by this ruling.
All right. Hey, I'm Austin Castleberry. I'm representing Chief Justice Roberts. Chief Justice Roberts is considered a moderate conservative when examined under the attitudinal model. On occasion, he will vote liberally on an issue, but he'll typically vote conservative. In Hedgepeth versus Washington Metro Transit Authority, he upheld the arrest of a 12-year-old girl, showing his legal strictness regardless of age. Chief Justice Roberts was appointed by George W. Bush, which means he was strategically placed as a conservative voice on the bench. I'm casting my vote in favor of the Department of Homeland Security. This is on the grounds that the DACA policy heeds the ability of DHS to enforce laws that were passed by Congress. If Congress had passed DACA, judicial review would perhaps have been required, but this is not the case. DACA was not passed by Congress. It was introduced by executive order by the Obama administration. If the executive branch can implement DACA with no congressional approval, then the executive branch should have the right to remove the policy with no congressional approval. Therefore, I'm ruling in favor of DHS due to the lack of jurisdiction over the issue presented before the court.
I'm Michaela Zumo, and I'm representing Gorsuch. Gorsuch, decided to rule more conservatively on this issue, thus ruling in favor of the Department of Homeland Security, similar to how I ruled with the majority in Trump v. Hawaii. That case gave the president authority to implement a travel ban on certain citizens from various countries due to those citizens being detrimental to the interest of the U.S. In this case, it can be seen that DACA is impacting the job market negatively for the Americans in the labor force due to an increase in foreign labor. This can be seen as very detrimental. I believe that it is not up to the Supreme Court to rule on immigration policies. These policies should be shaped by the executive branch of the government, which is why I ruled in favor of Trump in Trump v. Hawaii, and which is why I'm ruling in favor of DHS now. I also believe that the 14th Amendment is not being violated due to it applying to all immigration groups in the DACA program and not singling out a particular one. So Justice Gorsuch has made this decision using the strategic model, since he presided with Trump's goals towards immigration.
My name is Allie Early, and I am representing Justice Alito. On Justice Alito's behalf, I have decided to rule on the side of the Department of Homeland Security on the premise that the Equal Protection Clause has not been violated. If DACA were to be terminated, all DACA recipients would be treated the same regardless of their nationality and country of origin. DACA could also further future illegal immigration and potentially incentivize it in the United States. Rescinding DACA would pave the way for immigration policy to be properly made and enforced, which could make the immigration process safer for both Americans and immigrants in the future. He is also the son of an Italian immigrant, so he claims to be particularly receptive to the plight of immigrants coming to the United States. He has also been quoted saying that on matters of immigration, that Congress has spoken clearly, and as a justice, his job is to draw conclusions based on the laws at hand, and that the president can be challenged for not following what Congress has set. I believe that he makes this decision out of the strategic model. He might say that justices who ruled in favor of the Regents of the University of California could be acting out of judicial activism and wanting DACA to stand because of public opinion and support surrounding the issue. He was also appointed by President Bush and might want to go along with that president's administration and agenda. Also along the attitudinal model, he is one of the more conservative justices on the bench and might want to go along with conservative ideas. And with the legal model, Alito embraces a case-by-case policy exhibited by his reliance on text and constitutional statutes. So for these reasons, I rule in favor of the Department of Homeland Security.
My name is Harrison Trent, and I'm going to be talking about Justice Thomas. So Justice Thomas will be ruling in favor of the Department of Homeland Security. He's a strong supporter of executive power. After all, if one executive order can create DACA, why can a second executive order not rescind DACA? This is a decision that was supported in his prior decision in East Bay Sanctuary versus Trump, showing his leaning towards executive power in immigration policy. He also believes that equal protection under the 14th Amendment should be purely legal and not motivated by social status or race. Let's see. He is considered the most conservative justice on the court at the current time. After the death of Scalia, he took it upon himself to be that conservative voice. He also often votes against precedent. So I believe that he made the decision mainly based on the attitudinal model, again, because he is the most conservative justice on the court, and because of the death of Antonin Scalia, he needs to be that voice. Also, in the strategic model, he was appointed by George H.W. Bush, so continuing that conservative history in the court, as well as trying to further the goals of the Trump administration. Along the lines of the legal model, he often rules against precedent, so that really wasn't an option here.
Okay, my name is Danny Thomas, and I will be speaking on behalf of Justice Sotomayor. So different aspects of each model were incorporated into Sotomayor's decision. On behalf of the legal model, she has long been a defender or protector of immigrants' rights, and she is a major proponent of immigrant advocacy. In terms of the strategic model, she wants to further Obama's platform regarding immigration through her decisions on the bench. Some of these goals include reforming the system of acquiring citizenship to increase the number of legal immigrants to the United States and decrease the amount of immigration raids. However, the most important model, or the strongest for this case, I believe that would be used, is the attitudinal model. She has a liberal ideology, and she's a member of the liberal bloc of the court. She was appointed by Obama, and her ideology aligns with his platform. Her parents were also both immigrants from Puerto Rico, and they immigrated to the United States from Puerto Rico. And she has long been an advocate for Puerto Rican rights, particularly during her time at Princeton. She makes a strong statement and said about immigration and DACA specifically, and the rescission of DACA. And she says, "This is not about the law, this is about our choice to destroy lives," which I think shows pretty much how she would vote. So on behalf of her, I would say, it is in my opinion that the government is not being honest with their reasoning behind rescinding the DACA policy. The government is using the law to harm a specific class of individuals. This is not about the law as much as it is about the choice to destroy lives. DACA recipients or dreamers are individuals who did not make the decisions themselves to come here. And since they are here, they are working legally in the United States and paying taxes. Thus, these individuals are contributing positively to society and posing no harm or threat to others. DACA recipients thus should be a low deportation priority. With this being said, the Department of Homeland Security's decision to put an end to the DACA policy is judicially reviewable and is not lawful. This decision violated the Equal Protection Clause of the 14th Amendment because it was driven by discrimination against a particular class of individuals. It also violated the Due Process Clause of the 14th Amendment because it strips DACA recipients of their constitutional right to liberty and property interests without due process. Thus, the Department of Homeland Security's decision is unlawful and unconstitutional, and in turn, it is judicially reviewable. Lastly, it violates the Administrative Procedure Act's notice and comment rulemaking procedure, which requires public notice of a proposed substantive change to regulations and then seeks public input on the change. This decision is a substantive change, in my opinion, and did not receive the notice and comment period that it deserved. Thus, I have decided on behalf of Sotomayor that she would vote in favor of the respondent, which is the Regents of the University of California.
Hi, my name's Hayden Whaley, and I'll be representing Justice Breyer. I join Justice Sotomayor voting in favor of the respondent, Regents of the University of California. As the grandson of an immigrant, I came to this decision by means of the attitudinal model, as this case pertains to the fate of many young people lacking the same privileges I had. I also relied on the strategic model as a way to ensure the future of this program that is vital to so many. Through these models, I reached the conclusion that the Department of Homeland Security's attempted repeal of DACA and its benefits for the youth of America was done so illegally and with ill intentions. My first premise for this decision was the fact that DACA was created as a harbor for innocent youth, brought to America where they could create an opportunity-filled future and subsequently make significant contributions to the progress of our country. The criteria for eligibility of the program includes many restrictions, with one of those being not have been convicted of a felony, significant misdemeanor, or over 3 misdemeanors. With this being said, the program was specifically designed to prevent dangerous criminals, as this very administration has referred to them as, from receiving protection under it. With that being said, I see no reason as to why the program should be rescinded, and I also find the motion to be rooted in discrimination, as the current administration has a record of demonizing and creating misleading narratives around immigrants in America. The second aspect of my decision refers to the lawfulness of the motion to rescind DACA by the Department of Homeland Security. I found the motion to be in violation of the Administrative Procedure Act, specifically the notice and comment requirements, resulting in my ruling of the motion unlawful. I also agree with the Ninth Circuit Court's ruling, which suggests that participants would face unnecessary harm without the program's protection. In conclusion, I ruled in favor of the plaintiffs because the attempts to repeal DACA were done so in an illegal manner, and any other decision would set a harmful precedent that could call the court's legitimacy into question.
My name is Tracy Ha, and I will be speaking on behalf of Justice Kagan, who is joined by the opinion of Justice Sotomayor. Justice Kagan focused on the lack of legality and honesty over the case, and she really emphasized the reliance of the program and how important it is for immigration and the development of other immigration laws. She will rule in favor of the Regents of University of California based on an attitudinal model. She is known to be one of the most liberal justices on the bench, along with Sotomayor and Justice Ginsburg. She favors a pathway to citizenship for illegal aliens. For the other models in use, she might have used the legal model for her decision. The decision to rescind the program would deny children rights to equal protection in the Due Process Clause, and the inclusion of these clauses and laws goes in hand with the legal decision-making model. Also, the decision for DACA was an abuse of discretion and contrary to law under the Administrative Procedure Act, also known as the APA. For the strategic model, she was appointed by President Obama. She might have a goal in mind to uphold Obama's views and other elite opinions to further their agenda on immigration. Based on these reasons, I would conclude that Justice Kagan would vote in favor of the respondent.
I am Caitlin Marley, and I will be representing Justice Ginsburg. Justice Ginsburg will be voting in favor of the Regents of the University of California. This decision is mostly influenced by the attitudinal model due to Justice Ginsburg having more liberal views, and it's well known that she's an advocate for immigration, and also because her grandparents and father were immigrants. She claims that DACA is that the administration is claiming DACA is illegal, so they will not have to take responsibility for ending the program and any consequences that will come with that decision. Those consequences would include not only harm done to the individuals who are part of the DACA program, but also the state and local governments that profit from the economic activity of those participants. Some other models that could have possibly influenced her decision would have been the legal model. In the past, she has ruled in favor of respondents on many cases involving immigration. One of those being Zadivadas versus Davis, which was putting a 6-month limit on detaining illegal immigrants. And then there's also the strategic model. She was appointed by Bill Clinton, so she will most likely align with the views of that administration. She believes that the decision to rescind DACA is unlawful and violates the rights of those protected by the program.
When this case goes to court, either decision will have a huge impact on society. It's an important case because it involves immigrants and future childhood arrivals that are affected by the DACA program. However, based on our decision, we have a deadlock decision, which means that the lower court decision of barring the government from repealing the program stands. This means that the DACA program is safe for now, but in the future there might be cases similar, and the Supreme Court can rule in a different manner, considering that the deadlock decision does not set precedent. The implementation of the DACA program will increase economic opportunities for everyone. Applicants are able to get new jobs and get new bank accounts under the program, and they are able to be more integrated in society because the protection that are provided under the program includes not being deported. This might reduce the stereotypes of immigrants being criminals because of the increase of integration in society. Along with individuals, it will also affect the branches of government. In the judicial branch, cases related to DACA will be affected because the precedent will influence all the justice decisions. In the legislative branch, congressmen and congresswomen will pass laws that relate to the DACA program or to immigration. And for the executive branch, the president will sign or veto laws based on this program and this president as well.